I've got 3 points I'd like to make about the history. Okay, first of all, it's crystal clear at the founding and all the way till now that while the defendant, there are times when a defendant can certainly be denied access to counsel. When he does have access to counsel, he has a right to whatever assistance, including discussion of testimony, will be useful to him, right? So while there's certainly historical warrant, as the government points out, both governments point out, there's certainly historical warrant for saying that there are times when a defendant lacks access to counsel. So, in a prison in the middle of the night or something like that, sure. But there's no historical warrant for saying that when a defendant does have access to counsel, the trial court can say, well, you can talk about topic A, but you can't talk about topic B.
Would your rule apply to witnesses who have counsel?
No, because non-party witnesses, they don't have a Sixth Amendment right that a defendant has. This is a rule specific to the defendant.
They have a right to counsel, and they brought counsel.
During a criminal right to counsel.
Would it apply as well in civil proceedings to the defendant there?
No. The trial court can sequester non-party witnesses. This case isn't about that. This case is about the defendant as a witness.
In civil proceedings where there's a right to counsel, presumably? Yeah, it'd apply there, I think.
I don't know. I mean,
It's just that there's a long historical tradition of witnesses going on the stand being told something like what the trial court said.
Non-defendant witnesses.
So, Mr. Banner, can I just clarify? You're entirely rejecting the line that Justice Kagan drew to your attention, and you're saying that even during the day, let's say it was an hour, you're saying this is all about time. So even if the recess was for an hour for lunch, you are saying that the district judge cannot restrict what the counsel and the client, the defendant, can discuss. That's
No. So again, this is Perry. Perry says that during a brief daytime recess, the court can cut off all contact.
But what if he doesn't cut off all contact?
Well, and then there's a footnote.
So you're saying that once the district court allows contact, no restrictions?
No, because there's a footnote in Perry, maybe here's what you're leading up to, that basically the greater includes the lesser. That is, where the trial court can cut off access to counsel, the trial court could allow selective access to counsel. But that logic doesn't apply during an overnight recess when the court is held. There's an unrestricted right of access to counsel.
So it's all about time.
It's all about time.
If it were 3 hours, if it were 4 hours, and it was daytime.
Well, look.
How do you decide when it's too long?
So in theory, there could be some hard cases between 15 minutes in Perry and overnight in Getters. I have to say, in practice, the lower courts have had no trouble drawing this line. Daytime recesses are usually pretty short. Overnight recesses are much longer. It's very easy to tell, to draw that line. Now, in theory, if a court were to say, look, we're going to have a recess from 9 a.m. to 5 p.m. and we're going to be like a vampire court and just do it at night, maybe
Okay,
you get
so your
some
rule
hard
then is that any time during the day when there is a recess, the district court could, subject to maybe some extreme case where it goes on for too long and you have a vampire court, the court could say, you can talk to your lawyer about everything except the lawyer cannot manage your testimony during the day.
Again,
During the day.
During the day, again, because the greater includes the lesser.
Right. And you can't do that at night.
Correct, because at night...
It's unrestricted because Getters says that. So there's you can't have a line at night.
Well, Getters says that.
You can have a line during the day, but not at night, right?
Yeah, because Getters says that, but Getters was correct in saying that, right? Getters pointed out correctly that overnight recesses have always been times of intense strategizing, discussion, and so on. And whereas Perry said, well, not so for brief daytime recesses.